A large part of our firm's practice is defending people who are charged with sexual assault and other sexual crimes. I'm here today to talk to you about a topic that clients are very interested in. Obviously, sexual assault is a serious offense and they're facing sometimes years in jail. They want to know how we are going to win their trial. So that's what I'm going to talk about here today, strategies of how to win a sexual assault trial. This is not to be confused with how to get a charge dropped. I covered that in another video. You should watch that video in terms of strategies to try and get the Crown to withdraw a sexual assault charge without going to trial. So the case is going to trial, and I'm going to just start from the beginning about how we approach the case, the strategies we use, and how we can ultimately try and create reasonable doubt, because that's what it's all about. It's the burden of proof is on the Crown to prove a case beyond a reasonable doubt. And you have to realize reasonable doubt, that's a powerful burden. With the presumption of innocence the accused has, when you look at it this way, you know, if it's a he said, she said case, there's just one word against the other, you know, reasonable doubt is far closer to mathematical certainty than it is to mere balance of probability. You don't have to be mathematically certain, but it's far closer to that than it is to mere probability. This is not a lawsuit where you just believe one person over the other. The Crown has to prove the case beyond a reasonable doubt. In other words, the judge or the jury has to be sure it happened. And that's our job. When the client tells us they didn't do it, that it was consensual, or they didn't have any sex at all, or there's mistaken belief consent, we're here to try and create a reasonable doubt and try and win the case. It starts right from the get-go. The very first day you retain us, we order the disclosure. And that is the complainant's video statement, the police reports, all of the notes, all of the documents, the text messages, emails, whatever is in the Crown's possession, sexual assault evidence, a kit, that if they went to the hospital. These cases can be very complex. Sometimes there's hundreds of pages of disclosure in a big case. And you're facing years in jail if you lose this. So the client says, look, I didn't do it. Okay, well, let's look at this disclosure. So I get the disclosure, and this is before I even meet with the client to review it. And I'm analyzing it from A to Z, these hundreds of pages of documents. And I'm saying to myself, look, can I win this case? What are the odds of winning? What are the strengths and weaknesses of the case? What are the improbabilities in the complainant's statement? Does he or she have motives to lie? Are there inconsistencies? Are there things that don't accord with common sense? You know, what is the law in this area? Like, you have to apply all of your experience, skill set, law, and mostly common sense, frankly, as well, to understanding what are the odds of winning this case. So with that in mind, and that process can take many days in this type of case before I come to a full legal opinion. There's a lot of work involved, because again, we're talking sometimes hundreds of pages of disclosure, multi-hour video statements from different witnesses, including the complainant's statement, and all the after witnesses who saw her after or before, or the party or what have you. Sometimes there's many witnesses. But ultimately, it usually boils down to his or her word against the other. So that's why these cases are often winnable when the accused says they didn't do it. So I review that all, and then I meet with the client. So I start off by reviewing it, and it's the first of many meetings if this is heading to trial. I mean, too many meetings to count. I'm talking like, sometimes dozens of hours of meetings with the client before the trial commences. Now, I'm reviewing with the client. I go through it generally with them and details and specifics, and then I ask them for their version of events. So they're going to tell me one of many things. They might tell me they did it. Okay, so if you did it, we need to then try to get the best deal we can for you. We need to negotiate the lightest possible jail sentence we can. That's my role when they say they did it. They say they didn't do it. In other words, either A, it was consensual. She or he agreed to the sexual act, or I have a mistaken belief in consent. I thought they were agreeing, even though I was possibly mistaken. That's a valid defense. Or C, it didn't happen. It never happened. They're making this up. I also go through the client, any motives to lie, because there's often motives to lie in sexual assault cases. There's no question about that. And that's a powerful tool to win these cases when you can show a motive to lie as well. So the client gives me their verbal version of events, and I say to them, look, this is the first of many meetings. We're just getting started. But I want you to come back to the office tomorrow, for example, and I need you to go through these reports. It may take several days. There's hundreds of pages here. You need to watch the video. I need them to take notes. I need them to eventually put together a detailed statement. We're going to meet on multiple occasions, and I'm going to refresh their memory with more details, and that statement's going to go through revisions until the statement's in the chronological depth of detail I want it. All the client's words, but sometimes clients don't put it together in the way you need it to get ready for trial. So these two documents are going to become the basis for our defense. The Crown's version of events, 200 pages of different documents and evidence, and our client's 15-page, 20-page type statement with all the details. Now we get the matter set for trial, and whether it's a judge or jury trial, how do I approach this case? What do I do? Well, first of all, you don't have to prove motives to lie in any criminal case, but I can tell you, if you can find a motive to lie in a sexual assault case, that's a powerful tool. And there's so many motives to lie that are available in this type of case. Like, I'll just give you one of, a dozen that I can think off the top of my head. A client has consensual sex with a girl who's got a boyfriend. She felt guilty about it. The boyfriend found out. It was all consensual. And now all of a sudden, when the boyfriend finds out, she doesn't want to admit that, and she says it's a rape and calls foul. That happens. I hate to say it, that happens. There's one example of a false complaint and sexual assault. But the police believe her. She gave a statement. She sounded convincing. She was crying in the statement. So what do I do? Well, there's different strategies. If it's consensual, if it's mistaken belief consent, or it didn't happen, there's different strategies for each. But one of the things I need to think about is pretrial applications. In these instances, there's often counseling or medical records or other records, and I need to bring what's called a third-party records application to obtain those. There may be valuable information in counseling records where, for example, she told a psychiatrist or a counselor a version of events that might be different than she told the police. If I can get a hold of that, that's a powerful tool because her version of events is changing over time. It's difficult to get those records, but there are ways and means of doing it. That application is conducted, and I go through this in another video, which you should watch, several months before the trial. If the judge agrees with me, I get the records. It may be a powerful tool to help the case. There's also what's called a CBOIR application. Again, watch that video. A CBOIR application involves where normally the prior sexual history of a victim, a complainant, is never relevant to a sexual assault trial. There are instances where it can become relevant. For example, when the two parties have a prior sexual history themselves, but she's claiming that he raped her on day 200 of the relationship, that the prior sexual history in certain ways may be relevant, and we need to bring that application in advance of the trial to get a judge's order that we can introduce that relationship as part of the trial. Because let's face it, if we can't introduce that prior relationship, it wouldn't make sense, for example, if our version of events is that this woman came up to me at the party and said, let's go home and have sex now. That would be out of the blue. It wouldn't even make sense. It would make sense if they've been having sex for a year leading to that, a casual relationship where they did that type of conduct. Just giving you one example where it could be relevant. So, what are the important issues here we need to look at? We're now 3 months out of the trial. I need to start preparing very hard. I'm talking, I have done literally 200, 300, 400 hours of work on some complex rape trials. It takes a lot of work. Part of that work is preparing the client to testify, because in most sexual assault trials, not all, in most sexual assault trials, you're going to want the client to testify. And the only way for the client to effectively testify is when you prepare them. You sit in the office, you go through the questioning that you're going to go through with them, you practice Sometimes you might even videotape them and show them what they're doing wrong. Believe me, winning a sexual assault trial has nothing to do with who's telling the truth. A complainant who's false, if they're a good liar and the defense lawyer is not prepared, a lying person can come across very convincing. The client may be telling the truth, but they can't come across well unless they're prepared. It's all about body language, telling your story in a certain way, answering the questions properly, and that's your job as a lawyer to get them ready. You also need to cross-examine them. You need to pretend you're the Crown on multiple sessions, show them the questions they're going to be asked, tell them, and correct their behavior, whether it's their body language. Because not everyone's a natural public speaker, not everyone comes across well, but with proper preparation, we can make someone come across better so that they're believable. We've all run into people before who may be telling the truth, but it's just their body language is not good. They don't come across well. We need to correct that behavior before they hit the witness stand, because a big component of winning one of these trials is simply coming across well as the accused on the witness stand. If the complainant sounds great on the witness stand and you're not able to attack him or her, they sound great. It sounds quite believable. But if the accused does the same thing, well, what's the judge or jury to do? They're supposed to acquit, because you can't reject the evidence of the accused. It's a he said, she said, we don't know who to believe, there's a reasonable doubt. That's why it's important that's a big component of winning. Now, as a defense lawyer, I need to cross-examine that complainant and the other evidence, the police or other peripheral witnesses before at the party, after, about her demeanor. But let's focus on the complainant. I'm looking to challenge his or her credibility, that's truthfulness or believability, and their reliability. There's a difference between both. Reliability is accuracy. Credibility is believability. So I'm challenging that. I'm attacking their version of events. I'm confronting them. I'm showing inconsistencies. I'm showing improbabilities. What doesn't accord with logic and common sense? I'm trying to create inconsistency between their videotape of what they said to the police and what they're saying now, and breaking them down in the witness stand to show they're not telling the truth or they're not credible and reliable witness. That is an art form. It takes a lot of hours to prepare. You just don't show up in court and rely on your skill and experience. That's 50% of the equation. The other 50%, if not more, is hard work to be able to prepare that witness. And I'll give you an example. In the context of hundreds of pages of documents and witness statements and a video statement that's hours long, if that witness says A on the witness stand, A happened, and you've got a document in a sheaf of row on your desk that says B happened, you need to be able to pull that document out in 2 seconds, immediately, and confront her with it, and do this naturally and flowingly. It takes a lot of work to do that and needs to be planned. So if you can properly do that, you can challenge her credibility, you can show, again, confront her if there's motives to lie, confront her with your client's version of events. You're trying to mix up her version of events as well, show that she's not having a good memory. She can't remember this, she can't remember that. Her actions later were not consistent, with what she's saying now. And, ultimately argue that there's a reasonable doubt that maybe she's not telling the truth, probably she's not telling the truth, maybe she's not reliable, probably she's not reliable. And these are all techniques. And the bottom line, which I'll say to you, is this, is that the more prepared the lawyer is, and the more skilled and experienced the lawyer is, the better the chance you have winning. You need both. Some experienced and skilled lawyers are not working hard on cases, frankly. You need commitment and passion to win these cases. And it's my job, it's a lawyer's job, and not everyone likes criminal defense lawyers, believe me. But when my client says they didn't do it, it's my job as a defense lawyer to present their version of events in the best possible light, to cross-examine the complainant ethically. I'm confronting her. I don't sit there, I'm not yelling at her, I'm not aggressive. I'm doing it methodically, cleverly, trying to trap her into different areas. You're not sitting there, it's not like TV where I'm being aggressive with the witness. So the last thing you want to do during a rape trial in Canada in front of a jury or judge is start raising your voice at a rape victim. You do things subtly, you lead them down the garden path of attacking their credibility, but that's your job. And ultimately, if you can show inconsistency with what they said to the police, if you can show improbabilities in their statement and things that don't accord with logic sense, common sense, if you can confront them, for example, that they said something different than a counselor than they're saying now or to the police, and you confront them with your client's version of events and ultimately get them to change their story subtly or from cross-examining the chief, that's your job. It's an art form. It takes a lot of hours of preparation, not only the skill of years and years of work, but working on this particular case. The client takes the witness stand, testifies, and then of course, as a lawyer, whether it's a judge alone trial or jury trial, you're giving your closing address where you're summarizing everything. You're summarizing the inconsistencies, the improbabilities, how your client was a credible witness, how the complainant is not. And ultimately, you're asking the judge or jury to apply the WD test. Juries are an art form too. You need a skilled advocate to be able to persuade that jury and come across well to the jury, be polite to the witness. You're just doing your job. And particularly with juries, you have to be so polite, but you need to ask the questions that need to be asked of that witness, the hard questions. That's our role. Like it or not like it, believe me, I run into a lot of people who don't like criminal defense lawyers. It's a job, and it's an important job in society, and I'll tell you why. Believe it or not, there are people, everyone charged with criminal offense is presumed innocent. And if you don't have good defense lawyers on rape cases, murder cases, other cases, guess what? There's miscarriages of justice. So we've had many of those in Canada, and it's our role, and the Crown will agree with me. The Crown will agree their roles to avoid miscarriages of justice too, as well. They don't want that. They want truly guilty people convicted. So that's how, acquitted, I should say. That's how to win a sexual assault trial. It's a very difficult, stressful experience for everyone, including the Crown defense lawyer. It's a lot of work. And the reality is we do not want an innocent person going to jail, and we hope that only guilty people get convicted. And that's why we have to fight these cases. When the client says they didn't do it, it's our role to fight to try and win. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.